Hello, my name is Bridget Anderson, and I'm in Matthew Mobredy's Business Law class, Business 2311Z, and I will be discussing the case of Iroquois and Allied Indians versus Ontario. This case uses words in another language to which I am not familiar. I will do my best to communicate with the most respectful verbiage possible. I will pronounce things to the best of my abilities, but I in no way mean to offend anyone with my verbiage and pronunciation. I look forward to exploring this case further with you today. Starting off, I chose the legal principle, duty to consult. This is a very important principle involving Indigenous rights and reconciliation. The duty to consult is important, particularly when discussing changes that have potential adverse impacts on First Nations peoples and their land. Another aspect of this is accommodation, which is when adjustments are made in response to the Indigenous people's concerns. The duty to consult comes into effect when the Crown is aware of an act. The act could potentially cause harm, and an Indigenous group has rights that are either established in the past or may be proven in the future. As explained in the 6th edition of Managing the Law, the legal aspects of doing business by Dr. McEanes and Dr. Van Duzer on Pearson. I picked this case because I thought it was interesting for many reasons. First, I liked the throwback to COVID-19 represented through this germ. Bill 197 was an effort made by Ontario in hopes of modernizing the environmental protection and helping in post-pandemic economic recovery. Another thing I love about this case was the complexity regarding the environment and how the forestry industry can really affect people in both positive and negative ways. I myself am an environmentalist, and it was very eye-opening to read both points of view on the environmental protection and negative impacts both sides can have. For example, the Ministry of Natural Resources, MNRF, and the foresting industry mentioned in the case have affected the Indigenous people's ability to hunt because they were focused primarily on economic development, according to the case. Anything involving the environment fascinates me and challenges my thinking. There is some interesting background information on this case, including the long history of Indigenous concerns predating 1994 regarding the MNRF and the Minister of Environmental Conservation and Parks, also known as MECP, and the prioritization of economic growth negatively impacting Indigenous peoples. Between 1988 and 1992, there were multiple hearings held about the complaints. Following the hearing, the MNR 75 was created to regulate governance of the forestry framework. Another important note is the Crown Forest Sustainability Act of 1994. Chapter 25, Section 1 explains the protection for the Crown's forests and the economic and environmental needs of present and future. This highlights the different jurisdictions that come into play when dealing with Crown land and the duty to consult with Indigenous peoples. The Justice decision was similar to what we learned in the textbook. The province argued that passing laws falls under legislative sovereign authority, so they do not have a duty to consult, since the duty to consult typically falls under executive or administrative actions. The textbook explained that the duty to consult is primarily for reconciliation, rather than final say over government decision. Justice Morgan, the judge hearing the case, further reinforced the concept found in the bill could have adverse effects on Indigenous rights. The court found that modern reconciliation requires the government to consider their rights, however, is not legally required in this case. Expanding on this further, consulting with Indigenous peoples and matters that pertain to their land should be a matter of common courtesy. Having a conversation with an Indigenous elder does not take much time, but can have a big positive impact for reconciliation. Taking the time to ensure actions have minimal negative impact and is tremendously important for the sustainability of our country. The appellant's claim failed, and Justice Morgan's final decision concluded that Ontario did not have legal authority to consult in the legislative process. The judge Justice considered the economic situation of the province after the COVID-19 pandemic. Ontario was trying to expedite things in order to improve economic activity. The remedies mentioned in the textbook around the duty to consult included risk management and the different layers that make this so complex. Specifically in this case, prompt attention, the ever-evolving law, and satisfactory outcome are all reflected and how the justice made their decision. The justice had to take into account the global pandemic and the economic crisis that required prompt attention, considering the quick turnarounds required for the economy. The justice had to account for the evolving law, considering the duty to consult is relatively new, so each case is so unique and requires a deep understanding of the situation and potential outcomes. A satisfactory outcome may be the hardest of them all, considering they need both sides to agree. In this case, they ended the case with neither side agreeing to the cost of appeal, and the court found Bill 197 did not need consultation and did not fall within duty to consult. As for the MNR 75, this was found not to affect Aboriginal rights according to Ontario Reports, ontarioreports.ca, link provided at the end of the video. This topic is very important for future business leaders and will benefit from this case because it highlights the importance of consultation for future economic growth. More importantly, how the two need to work together for a more prosperous future. Working with Indigenous peoples and following the duty to consult will lead to further economic growth and interpersonal relationships concerning all provinces and Indigenous peoples. Future leaders will need to learn how to work with everyone in order to find the best solution for all involved. Looking at this from a business point of view, having more people on board with your decision leads to a higher profit and a higher reward. In conclusion, this case triggers thoughts on whether the duty to consult should be extended in the legislative process. The court did emphasize the importance of reconciliation and that should be continued and passed down to future leaders.